Hello again and welcome to Law and Life. My name is Shashank Mishra here with eminent senior advocate of Supreme Court of India, Subodh Markandeji. In this episode number 32, we will be discussing on the topic inefficacy of the remedies to enforce Supreme Court judgment and orders. On that, my first question to the sir is, what is the provision in the Constitution to enforce the judgment and orders of the Supreme Court?
So, Clause 2 of Article 142 lays down that Parliament may by law lay down the manner in which the orders of the Supreme Court will be enforced. It also provides that till such time as the Parliament makes such law, the President of India may by order provide. But since 1950, no law has been enacted by the Parliament providing for the manner in which the orders of the Supreme Court will be executed and enforced. The President has passed Constitutional Order number 47, CO 47, popularly called, which is very laconic and unspecific. It refers to the manner of executing the orders and decrees of the court below, and the same procedure is made applicable mutatis mutandis for executing the orders and decrees of the Supreme Court. But what about the orders passed in exercise of Supreme Court's writ jurisdiction or original jurisdiction, that is suits between states and union, uh, one state and one or more state and the union and vice versa, or advisory or disciplinary jurisdiction? No provision has been made.
So, how effective is that remedy?
No, therefore the remedy is not effective. As I said that yes, the presidential order takes care only of the orders and decrees passed in exercise of Supreme Court's appellate jurisdiction. But as I said, what about the other jurisdictions? The writ jurisdiction, the advisory jurisdiction, the disciplinary jurisdiction, and so on. So no provision has been made. So it's a very ineffective remedy.
Then, so how the judgment and orders of the Supreme Court enforced?
So as I said, the remedies provided under Article 142.2 are not at all efficacious. Taking example of the orders passed in exercise of writ jurisdiction or appeals from the exercise of writ jurisdiction by the High Courts, there is no efficacious remedy, and this is the main bulk of litigation in the Supreme Court. And Parliament has not made any law. Presidential order is laconic and unspecific about jurisdictions other than appellate.
So, what is the way forward, sir?
So, uh, so you see, the judgments and orders of the Supreme Court are the enforcement of those judgments and orders and decrees of the Supreme Court is, as I said, very um, unsatisfactory. The litigant is left with only one choice, that is to say, move the Supreme Court for punishment of contempt of its order. These proceedings, are penal in character, resulting in punishment of the contemner. A citizen obtaining a writ, judgment, or order in his or her favor is mainly interested in the implementation of the order and not punishing the officer or whosoever is, responsible for uh, non-execution or failure to execute. So experience has shown that contempt proceedings are not very efficacious because for one thing, the bureaucrats become very uh, hostile because they fear they can, and they are hostile to the petitioner because they don't like to be punished. So the citizens' problem is also compounded by the difficulties in finding out precisely who disobeyed the order uh, and fixing the responsibility of officers responsible for non-implementation. Now, the executive processes are very nebulous in character. So, another difficulty is official apathy or hostility to citizens' just causes and non-specification of time frame, which is also aggravated uh, all these difficulties. So, these are the problems faced by the citizen who obtains an order or decree in jurisdictions other than the exercise of appellate jurisdiction.
So that was all, sir, and thank you, sir, for joining.
Uh, so, as I said, there is a lot of challenges in executing the decree, decrees and orders of the Supreme Court. So, the only way forward, in my view, is that this problem can be solved by framing of specific rules by the Supreme Court in exercise of its own power under Article 145 of the Constitution. Such rules can specify the nodal officer responsible for executing writs, orders, uh, judgments. Then, secondly, time frame is very important. Time frame for such execution and delineating the necessary steps that they are quick and effective as well as orderly execution. Another serious problem which is faced is that even when the declaration of law is made by the Supreme Court, the state, as understood in Article 12, does not automatically extend the benefit of such declaration of law to other people, other citizens who are similarly situated. Although this is a this is obviously a necessary corollary of Article 141, which says that declaration of law by the Supreme Court shall be binding on all the civil and judicial authorities. So consequently, what happens is that citizen is obliged to file individually thousands of cases, thereby inundating the dockets of the Supreme Court and High Courts. So if the writ petition is filed in the High Court, then invariably both the parties come to Supreme Court. Therefore, dockets of Supreme Court are also flooded. And in the Supreme Court these days, matters remain pending for, let us say, about 10 years. That's the normal life of a case in the Supreme Court. So, uh, the present, so this acute problem can be solved by following the dictum laid down by Supreme Court itself in Amritlal versus uh, Collector of Central Excise. So there the Supreme Court laid down the following law. I'm quoting. When a citizen is aggrieved of the action of the government department and has approached the Supreme Court and obtained a declaration of law in his favor, then others in like circumstances should be able to rely on the sense of responsibility of the department concerned to give the benefit of such declaration in all equally situate, to all equally situate, without the need uh, to take their grievances again to the court. So this is, if they follow the dictum in Amritlal Berry's case, then definitely this problem can be solved. Because then each individual person will not be required to again come to High Court or Supreme Court. So, but that is for the governments to uh, enforce. So I have come to the end of this episode.
Thank you, sir, for joining and telling us all about that, sir.
Thank you.